Good morning and welcome to today's webinar, Trustee Selection and How to Choose the Right One for You, presented by Elville & Associates Managing Principal and Lead Attorney, Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville & Associates, and I'll be moderating today's event. So we have many newcomers to today's webinar series, and so welcome to everybody if you're new to our presentation or are returning again to see us. So you, as always, are in listen-only mode. However, you do have a voice. If and when you have questions, please note them in the questions panel on the right-hand portion of your screen, and we will take time throughout the presentation to address all your questions. Your questions really add value to the presentation and help others learn, so don't be shy in posing your questions at any time, and I'll make sure Steve gets the questions. You received the presentation yesterday, or actually this morning, I'm sorry, by email for me to take notes on it if you wish. If for some reason you did not receive the presentation, it is currently in the section marked Handouts in the panel on your screen to download at this time. For our professionals on today's webinar, welcome as always. You may receive 1.5 continuing education hours for attending. So per my attendance records requirements, please email me your board ID number if I don't have it already. And for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval. Everyone will also receive a post-webinar feedback email right after the presentation, and we do ask that you take just a couple minutes to fill out this very simple survey to offer us your feedback about the presentation. And as always, we read and value every comment that you have to share with us. It's also an ideal time to request a consultation with Steve for any planning needs that your family and you may have now or in the future. And here at Elville & Associates, we always look forward to being a resource to you here at the firm for you. So briefly, we have a lot to cover. I'd like to give you a brief overview about our firm and share a little bit about Steve for our newcomers especially. You should be able to see my screen here, which I'm sharing. So Elville & Associates, we were founded in 2010 in Columbia by Managing Principal and Lead Attorney Stephen Elville. We have many different practice areas here at the firm that we focus on: estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations. Steve and I are coming to you live from the Columbia Gateway Community location here in Columbia. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, client education, and superior legal technical knowledge. And we do offer and focus on education here at the firm. We do that in many ways through our planning processes with our clients. We offer over 100 educational webinars and workshops in the communities that we serve each year. And also by way of our accredited client care program, or CCP as we call it. We are one of only 2 firms in Maryland to have an accredited CCP through the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville & Associates. A little bit about Steve. His work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning with an emphasis in areas of tax planning and asset protection. A member of many different national membership organizations, the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys, among many others. He works to bring peace of mind to clients by creating solutions to the needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve talk and presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Also, Steve was named to the Maryland Super Lawyers list for a 7th time in 2022, so congratulations to Steve. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I'm very privileged to be the executive director of. So if you'd like to learn more about the Elville Center and how we work to make a musical difference in the lives of children each day, please reach out to me offline, and I'll be very, very happy to share our story with you. So with all that said, we are going to go ahead and get started. I have a brief poll that I'd like to share with you to get to know our audience. We always share this poll when we do this workshop on a quarterly basis. And the poll is, I can get it pulled up here. What has brought you to today's webinar? Please select the response that applies to your current situation. And the choices are, I'm a grantor, I've established a trust before, I've been or am a trustee of a trust, I'm the beneficiary of a trust, I'm considering establishing a trust, or I'm an advisor here to learn to better serve my clients. So a lot of choices there, but make the choice that best suits your situation and what's brought you here today. And we appreciate you being here with us. All right, we'll give it just a few more seconds. All right, and with the majority of the votes being cast, we have 44% say, I'm a grantor, I've established a trust before. Nobody has said I've been or am a trustee of a trust, or I'm the beneficiary of a trust. Another 47% say I'm considering establishing a trust. The numbers are going up and down a little bit here. And then 16% say I'm an advisor here to learn to better serve my clients. So welcome, whatever reason that's brought you here today. And I'm going to go ahead and control the slides today. Switch it up a little bit. Let me go ahead and pull my presentation up. Let's see here. Whoops. Bear with me one second here. There we go. Okay, Steve, can you see that okay?
I can, Jeff. Thank you so much. I'm just going to go ahead and get started. Thank you. Well, good morning, everyone. And thank you, Jeff, for that nice introduction. Welcome to our webinar today. It's Friday morning, and thank you for spending your valuable time with us on a Friday. It's a beautiful day out here in Maryland, and wherever you are, and for whatever reason you are interested in this topic, I am glad you're here. Jeff is an expert moderator. By the way, Jeff, I see you have your holiday colors on there, so more power to you there in advance of the holidays. And so we are looking forward to the weekend, and I hope you will get a lot of information out of this workshop. I noticed as Jeff was reading the poll, I noticed some of you have established trust, some of you haven't, some of you are, whether you have or haven't, whether you're in the process, it's always a good time to look at our trustee selection, because what could be more important, right? Arguably, what could be more important than selecting trustees for not only the now, the here and now, but also for the long-term future. So today's discussion is going to be what I would call a mini master class on this subject. And we're going to talk about how to choose trustees, but I'm also going to be giving you background information about trusts themselves. So as you think about who your trustees should be and what you want in a trustee, and who your potential selectees or who are the persons that could be selected as trustees, you will not only be thinking about that issue itself, but you'll have background information. We want you to walk away today with substantive information that you can use by having this presentation as a tool. As I mentioned, Jeff is an expert moderator. He will take your questions. If you're having any difficulties technically or anything, if you can't hear me, please let Jeff know. And we're going to stop occasionally throughout the presentation to allow you to ask questions. So again, thank you for being here. And without further delay, we're going to get right into the presentation. So we're going to discuss today what is a trustee and what are their responsibilities. What are the types of trustees and their characteristics? There are many different types. There are many different ways of looking at trustees. What are the advantages and disadvantages of that? We're going to explore the concept of the perfect trustee, setting a benchmark of perfection and then going from there. So we believe in perfection in estate planning here, and we want to think in terms of our trustees as in perfection. Now, we're going to talk about something that is kind of the fundamentals of today's workshop, which is why is trustee selection so important? Just sometimes we may be getting the cart before the horse here. We're talking about all this trustee selection, but not talking about why it's so important. So we're going to talk about that. Trustee selection in the plan design. You know, what if we have this type of plan versus this type of plan? And why is it difficult to think through this and yet so crucial? We're going to talk about trustee roles in wills and trusts. Now, this is where we're really going to be getting down into the fundamentals. We're going to assume that you know nothing about wills and trusts, and yet I know that many of you on this webinar are very, very smart people who have had life experiences, and you may already have documents in place. So we know that you know some of this, but we're also going to assume that there are people in the audience who don't really understand any of this. So we're going to talk to you from the ground up. What are some of the reasons to think in terms of appointing a corporate trustee or an independent type trustee? So we're going to talk about that. And we're going to talk about the risk in trustee succession. This is unfortunately something we have to be aware of and we have to plan for with hopefully designing flexibility into a plan. Okay, Jeff, let's go to the next slide, and I appreciate you handling the slides today. So what is a trustee and what are their responsibilities? We're going to get right down into the fundamentals here. So Jeff, we'll go to the next slide. Well, of course, a trustee has to administer the trust. They need to administer the trust according to its terms and provisions. We're going to talk about that many times in this presentation, and they need to follow those terms and provisions and keep accurate records. Okay, why? Well, they have to be accountable. Our trustees need to be accountable to the beneficiary, and they have fiduciary responsibility, right? One of the things that I see in the world today is trustees not necessarily accounting every year in the way they should. It seems to me in the older days, when I was much younger lawyer, we would see many more annual accountings. And I just think that with so many records being produced through brokerage statements and many other types of things that are readily available today, the inclination to get away from the fiduciary responsibility of accounting every year is something that is problematic. So I just want to make sure that we flag that as something to always keep in mind. One of the trustees' main duties is to account. The trustee has the obligation, of course, to make distributions, and those distributions could be mandatory according to the terms of the trust. For example, mandatory income versus discretionary income, discretionary payments of principal according to the terms of the trust. The trustee has to make investments and do so prudently. But the thing to remember here is the trustee does not necessarily have to do that themselves. And they really shouldn't, in my opinion, be making investments themselves unless they are a professional investment advisor. And instead, the trustee should hire professionals, in my opinion, almost exclusively should hire professionals for this investment management. And also, there are reasons why the trustee would want to do that, to protect themselves, because a trustee has liability and as I mentioned, fiduciary responsibility. The trustee, of course, wants to communicate with the beneficiary, and to not do so is a breach of fiduciary responsibility. Some of you may have heard me now say that word several times so far in the early going. Fiduciary responsibility, a very high level of responsibility, right? To communicate with the beneficiary, to make sure that their needs are being met, to make sure that they have information, to make sure that the allocation of assets, for example, is in coordination with the age and the lifestyle and the needs of the beneficiary, and understanding that has to do with communicating with them and making sure that their needs are met. To ensure all tax filings are complete. So trusts have their own tax reporting requirements, slightly beyond the scope of this discussion today, but that's one of the trustees' responsibilities. And then to manage the assets in coordination with the professional financial advisors usually, and CPAs, and all of the professionals that are involved, taking into consideration the income taxation of trusts, which are kind of a special area. We'll briefly touch on that today. Okay, Jeff. Now let's talk about the definitions and trust basics. Okay, we've gone into quite a bit of trustee responsibilities, and I've used a lot of definitional language. So let's talk about really fundamentally what is a trust. Okay, well, a trust is a relationship, really. It springs from an agreement between a grantor. This is the person who creates the trust. Now, in the old days, this used to be called the donor or the trustor, but now in modern terms, it's called the grantor, the person who creates a trust, and the grantor says who the trustee is going to be to provide for the benefit of the beneficiary. Now, as many of you are aware, now we have this trust that's been created, and that trust describes and prescribes the types of responsibilities and duties and role of the trustee and what the beneficiary's benefits are. And as I just mentioned, the settlor or trustor or donor, those are the older school terms for a person who creates a trust, but now we call this a grantor of a trust. This is the person who establishes the trust. And again, we're drilling down into the fundamentals. The trustee is the person who accepts. They accept the trust property and they say, I agree to manage this and I agree to distribute the property for the benefit of the beneficiary as directed by the grantor. So the trustee, again, is a fiduciary. They have responsibility. The beneficiary, the bottom bullet point here, is the person or persons for whom the trust is intended to benefit. How will they receive distributions and those benefits? When, okay? And what trust property is used? So really making sure we're on solid ground here about what a trust is, who the grantor is, the person who creates the trust, who the trustee is, the person who is tasked with the fiduciary responsibility, and then the beneficiary who benefits from that trust. All right, Jeff, let's go to the next slide. Now, I promised as we get into all of the trustee duties and how to think in terms of trustees, so you have some framework of how to think in terms of your selections, I want to now talk about some basics of trusts. So basically, we have revocable trusts, and many of you are familiar with those, and we have irrevocable trusts. So for those of you who are not familiar with this, let's get right into the basics. A revocable trust is nothing more than a substitute for a will. So let's say a person is talking to a lawyer about basic estate planning. So basic estate planning is about evaluating wills versus trusts. Now these are the very basics. Am I going to leave my estate through a will-based plan, or am I going to leave my estate through a trust-based plan? And that trust, 9 times out of 10, is a revocable trust, a trust that can be amended. If we look at the definition here, it can be modified, it can even be revoked, okay? And the revocable trust is something that we're going to talk about in a few slides. That is the very most fundamental grantor trust. So we talked about grantors of trusts, people that create trusts, but then for tax purposes, there is something called the grantor trust, which we're going to see in a few slides. The revocable trust is the most basic of all grantor trusts. And what does a grantor trust mean? Because we're going to cover that here in just a few minutes. It means that a grantor trust is a trust where the tax is passed along to the grantor. So it's very simple. Grantor trust means the grantor pays the tax. So someone who does not have a revocable trust, obviously they have a tax ID number, they have a social security number, and then when their trust is created, their trust is nothing more than a substitute for a will. It's a will alternative. And that revocable trust is still taxed to the person who created it because the tax ID number of that revocable trust is the person's social security number. So in that sense, the revocable trust is in effect an extension of the grantor himself or herself. Now, an irrevocable trust cannot be amended or modified except there are techniques now to be able to do that. But generally speaking, for our purposes, an irrevocable trust, in my opinion, is a trust with a special purpose. So let's just say someone was creating a charitable trust. Well, that's going to be an irrevocable trust. Or a life insurance trust. That's going to be an irrevocable trust. A special needs trust could be an irrevocable trust, even though many times those are drafted as revocable trusts these days. Various types of trusts are irrevocable. So they can't be modified or changed except through court intervention, or there are some other techniques such as non-judicial settlement agreements and other types of amendments that can be made by a trustee, meaning an independent trustee, or through a trust protector. All right, Jeff. All right, now we've talked about revocable trust versus irrevocable trust. Jeff, I think I may have skipped over one thing I want to cover in the prior slide, if you could go back one more. As we continue to wrap up there, I wanted to point out that many irrevocable trusts are grantor trusts. So for example, a life insurance trust, even though it's irrevocable, it can be and oftentimes is a grantor trust, meaning the grantor still pays the tax even though it's an irrevocable trust. But there are many irrevocable trusts that are non-grantor trusts. The trust itself pays the tax. So we're going to talk about that, but I didn't want to skip over that. Revocable trusts are grantor trusts. Irrevocable trusts could be grantor trusts, but oftentimes are non-grantor trusts. Okay, Jeff. Now, traditional revocable trusts, just like I mentioned just a minute ago, these trusts really manage our property. The person who establishes this trust wants to avoid probate, and they can avoid probate for out-of-state property. Let's say one of you on this call has a house in Florida or South Carolina or Delaware or Pennsylvania or West Virginia. That second home can also be and should be usually in the revocable trust, and that is going to avoid probate not only in Maryland, but in that state. There could be certain reasons for privacy or potential cost savings in the overall administration of the trust why someone would implement a revocable trust. The disadvantages are that sometimes revocable trusts can be confusing, and there are some increased costs of establishing a revocable trust. Now, that's just one example or one definition of how to look at a revocable trust. Now, there are trusts for at-risk beneficiaries. There might be a trust that is established that is to protect the person from themselves. So for example, a trust could be established for a minor child or a person who is a spendthrift, person who cannot manage property, okay? If we look at the second bullet point, a trustee holds property. Sorry, Jeff, we want to go back there. The trustee holds, Jeff, if we could stay right there. Perfect, thank you. The trustee holds property and uses the property for the best interest of the beneficiary, no matter what that at-risk situation is. And the trust can be in perpetuity. So a trust could be forever. We might call that a bloodline trust or a dynasty trust. Or the trust can terminate at a certain age. So some of you may have wills where there's a trust for young beneficiaries and that trust terminates at a certain time, let's say when the beneficiary is 25 or 30. So what these slides right here are starting to show is that there are various types of trusts: revocable trusts, irrevocable trusts, trusts at death, and trusts that are created during life, and so forth. So I just want you to start thinking about those things. Okay, Jeff. Okay, continuing on, thinking about common trusts. Beneficiary controlled trusts. So we can actually establish trusts today where there are beneficiaries that are obviously the beneficiaries of those trusts. But in Maryland, those beneficiaries can be their own trustees. There are advantages and disadvantages of that. These trusts can be established through a revocable trust or a will. They can be established for a spouse. As I just mentioned, the beneficiary could be the trustee and the sole beneficiary. But again, there are pros and cons. As long as the assets remain in those trusts, the trusts are protected from most creditors, although there are exception creditors in Maryland. I think there's a state such as Nevada where there are no exception creditors, but Maryland is not one of those states. Many of you have heard or even have special needs trusts. So there are two types of special needs trusts. Third-party trusts, those are trusts where an individual leaves money into a supplemental needs trust for the benefit of their disabled loved one. And that third-party trust is kind of the bread and butter of estate planning for special needs. And then there's something called the self-settled trust, or what is called the first-party trust. And the first-party trust is where the disabled person receives money that they should not necessarily receive, usually in an accident settlement, a malpractice settlement, or an inheritance. Someone has left the disabled person money that they should not have. And of course, the purpose of the special needs trust is to hold the assets for that person with disabilities and enhance the quality of their life without compromising any kinds of public or means-tested benefits. All right, Jeff. Now, again, we're going to intentionally be redundant throughout this presentation because we're driving home certain information. And one of those things that we're driving home is that the trustee is the person who's accepting the property in trust. They are managing the property and directing the property for the benefit of the beneficiary. And as you now kind of have a little bit of a framework about trusts in general and the limited time that we have today, you now can start to think about again, who is this person or this organization that we're going to implement as trustee, knowing some of their duties and responsibilities and the definition of what a trustee is. And the beneficiary is the person or persons who are benefiting from the trust. And the trust assets are going to be used for them in accordance with the terms and provisions of the trust. Okay, Jeff. Now, I alluded to this earlier. We're going to again nail this down. It's a very non-intuitive thing. Grantor trust versus non-grantor trust. Why am I educating you on this? Because I want you to know that as you think about your trustee selection, your trustee needs to understand these things. Your trustee needs to be a person who is interested, who is willing to absorb this information, because this will have something to do, a lot to do, with the taxation of the trust. So Jeff, let's go to the next slide very briefly. We're just going to cover this briefly. Well, I apologize, Jeff. Let's go back. I didn't mean to get this far yet. So I'll just describe this one more time. The grantor trust is the trust where the grantor pays the tax. A non-grantor trust is where, and this is what most of us are going to be concerned about now, a non-grantor trust is the trust that pays its own tax. Many of you who are on this webinar, I'm just going to make the large assumption that you are concerned about the long-term future, about who will be the trustees of trusts that are going to last a long time. And those trusts are usually trusts at death, or they are irrevocable non-grantor trusts that are created during life. And so as we think about the non-grantor trust pays its own tax and usually files a form called the 1041. So the form 1041 is the trust, or what we call the trusted estate tax return, the fiduciary tax return we call it. And that 1041 measures the income and dividends that that trust produces during the year. And that form has to be filed timely, and your trustee needs to understand the tax implications of the trust. And that's why I'm emphasizing this. So understanding the difference between a grantor trust, where the grantor pays the tax, versus a non-grantor trust, that's one of the things you want to keep in mind as you think about your trustee. All right, Jeff, let's go down to the next slide. I apologize. One of the things your trustee needs to understand, other than the tax ramifications of the trust and all of the other duties, is wrapped up in that is the duty to make sure that beneficiaries are informed and that they receive notice. So under Maryland law, the Maryland Trust Act since 2014, there is this term called the qualified beneficiary. And the qualified beneficiary is entitled to notice. As you see these notice requirements here, the trustee has to provide notice. Now, in estates, meaning probate estates, of course, interested persons and beneficiaries receive notice, but this was not always the case in Maryland law. And in 2014, the Maryland Trust Act now mandated and now mandates that beneficiaries are entitled to information and they are entitled to notice. So you'll notice, or you'll look at these notice requirements here, and you'll see that there are certain obligations for the trustee to provide this notice within certain times. And if they don't provide the notice, then they can actually be held accountable and even removed as trustees because they are breaching their fiduciary duty. Now, look at the very bottom bullet point here. It says, notice that these requirements cannot be waived. And therefore, we don't really have in Maryland something called a quiet trust. So in some states, like our friends in Delaware have, you can actually have a trust where the beneficiaries don't really receive this kind of information. But in Maryland, there is really no practical possibility of a quiet trust. So if you are a person and you are selecting trustees who are going to have to deal with beneficiaries who are not either easy to deal with, they have issues, for better or for worse, we really cannot avoid giving them information or notice. All right, Jeff. And again, I'm talking about the rights of beneficiaries under the Maryland Trust Act, and this is what we are dealing with, and this is what your trustee needs to know. This is part of their duties. So it says the right of a qualified beneficiary basically is to receive information. And in my opinion, they are entitled to all information. And they are entitled to a copy of the trust agreement and the annual reports and reports upon the termination of a trust. And some of you on this webinar may be worried that your trustee is going to have liability and it's a lot to ask of them. And I couldn't agree more. It's a lot to ask. It's not an easy job. And but the thing to remember is that the trustee is entitled to be released from liability when they are distributing a trust, meaning let's say a trust was terminated and it was distributed, the trustee is entitled to be released from liability, and hopefully that would happen. Also, during the trust relationship where the trustee is serving, there are various types of trustee insurance that can be purchased. So I would agree with you if you were to say, wow, Steve, this is a lot that I'm asking somebody to do. I would agree with you. And so trustees need to understand not only their duties and responsibilities, but they also need to understand how they can protect themselves and how they should be represented in their process of administration so that they always are on the straight and narrow path and are not going to be getting themselves into trouble or embarrassment by not following the guidelines. Okay, Jeff. Now, what I've alluded to earlier is that the trustee should hire professionals. And when I'm talking about professionals, I'm talking about attorneys, financial advisors, CPAs, and others. And in certain types of trusts, it could be advocates, or it could be life care managers. It could be hiring a psychiatrist or a physician to advise the trustee about something that's going on with the beneficiary. But let's focus here for just a moment on the financial advisor. And we here at Elville & Associates are big proponents of the planning team. the advisory team, and it consists of those individuals I just mentioned, those professionals such as CPAs, financial advisors, attorneys, life insurance professionals, elder care professionals. Okay, but now focusing on the financial advisor. So what is their role in the trust administration or the trusteeship? Well, the trustee should have a relationship with the financial advisor that they have confidence in. And why? Well, because the trust is going to create liability for the trustee, and the trustee, of course, can't control the stock market. The trustee can't control investments. So the trustee is going to want to go to the financial advisor and say, listen, I'm establishing a new trust. I'm the trustee. Here is the tax ID number. I'm establishing this trust. I want to do the highest and best I can for this trust, and I have liability. I want to make sure this trust is properly invested. Please give me an investment policy statement. An investment policy statement. And as a trustee, your trustee is going to want to get that investment policy statement to be assured that the trust is being invested properly. The trustee is not going off into right field and doing what they think is best. They're relying on financial professionals to do this, and therefore they are minimizing their liability by showing the world they are doing the right and proper thing. Now, once we establish a relationship with the proper financial advisor, we want to deal with them and let them do what they do, which is design their end of this relationship. Are there multiple trustees? How will statements be sent out? Making sure that there are funds available. So the person who you appoint as trustee, they're going to want to make sure that they have liquid funds. So for example, it would be very common practice to have a brokerage account for the trust and then to have a related money market account for the trust under the same tax ID number. And there's no limit about the amount of accounts that can be open. There could be a bank account for the trust, a money market account for the trust and the brokerage firm, and then the brokerage account itself, not to mention IRAs that may be owned by the trust. So this financial advisory role is very, very important, that you work in collaboration with that person and that there's real confidence in that relationship. One of the things that could happen is that the trust that your trustee is working on and they are the trustee of, is there could be in-kind assets. There could be assets that are transferred in there that are not liquid assets. So we want to make sure that there are potential funding of, let's say, real estate into a trust. There's been a piece of property like a residence left into a trust for someone. That's going to be an in-kind transfer, okay? The financial advisor, back to them real quick, when they are setting up this trust for you, for your trustee, they are going to make sure that all inherited assets receive a stepped up basis as long as Congress allows that. So we've got assets that have been liquidated and they are going to be cash in the trust. Those should be properly invested depending on the circumstances. And then there are going to be in-kind assets, and there's going to be all kinds of back-end things that the financial advisor is doing, such as setting up this relationship for your convenience or your trustee's convenience, and making sure that all assets are stepped up according to the law. All right, Jeff, let's go to the next slide. And as we continue, I alluded to the trustee managing the portfolio, okay? We want to make sure that the portfolio is properly allocated. Now, the non-professional advisor trustee, the person who is a friend of yours, or the person who is a person of confidence that you have confidence in, a relative, that person is not really qualified to make this decision. So that's why they need to rely on professionals. There are some people on this call that possibly know me, and we know that we've seen cases where there are trusts that are improperly allocated, trusts that are allocated toward growth when they really should have been allocated towards income. So this is a very high level discussion, and your job, or your trustee's job, is to act as a prudent person would and to make sure, again, that you're exercising your fiduciary responsibility and that you are protecting yourself at the same time with an investment policy statement, but understanding the cash needs of the trust, making sure that we understand about expenses, make sure we're developing a budget. A lot of those kinds of things are the background roles of the trustee. So again, I give you this background information not to just focus on trusts themselves, but to give you the background as you think about these are the things my trustee should be dealing with at a very high level. And as I consider who that's going to be, I now have some framework about how to think about that. Okay, Jeff, let's keep going. And thinking about the trustee's duties, we want to really think about these concentric circles. And I always like to take just a second here, and I always like to smile a little bit because every time we give this presentation, I always challenge Jeff to please include some photos here of trustees, because we're looking for the perfect trustee. We're looking for that person who understands all of these things. So let's start with accountability down here on the left side. As we mentioned, the trustee has the duty to account, to keep accurate records, keep the beneficiary informed, complies with the statutory duties of notice and information. And on the financial side, the trustee needs to make these proper investments, not necessarily themselves, but with professionals. They're hiring professionals. They may not be tax preparers themselves, but they have hired tax preparers. They understand the fundamentals of the taxation of the trust, and they can converse about it. They understand it. And then some beneficiaries who are at risk or special needs beneficiaries, the trustee is going to want to be an advocate and understand and work toward the best interests of that person. Understand public benefits if it's a person who is disabled or chronically ill or quasi-disabled. Promote the independence and well-being of that person. So this is where we want to be in the middle of these concentric circles. We want to find that perfect trustee, and that's challenging enough, but then we want to make sure we're selecting fiduciaries that are successor trustees, and that's what makes it even more challenging. I'll say that at the end, I'll say this, I should say, at the end of the presentation, but I'll also say it now. At Elville & Associates, we have a process for helping clients work through these issues. So if you're in the middle of this presentation right now and you're feeling somewhat overwhelmed or confused about what direction to go in for trustee selection, just know that we here at our firm, we have a process of taking you through a series of exercises and thought processes to play devil's advocate, to really bring out the situation and help you come to some conclusions about trustees. So don't worry about that as we continue to give you background and scope about what a trustee does and what trusts are all about as you continue to think about who is the person I should choose or organization. All right, Jeff. Now, obviously, we've talked about a lot of information and a lot of substantive information about trusts and taxes and trustee responsibilities, but why is this so important? And intuitively, many of you, all of you probably understand this already for your own reasons. Why? Well, we know that all estate planning is goal-driven, G-O-A-L, goal-driven. And as you think about your goals, you have desires, intentions. Some of those desires or intentions are on the simplistic side. Many of you feel comfortable in keeping things very simple. But if you're leaving further trusts, and if you're leaving more complex estate plans in place at your passing, or creating complex trusts during your lives, that's where these details become more important. If we are creating marital trusts for spouses that are surviving, if we're creating trusts under wills or revocable trusts, further trusts for children, nieces and nephews, grandchildren, whatever the situation may be, these trusts can last a long time. So that's my assumption this morning, is that many of you are thinking about those longer term trusts. Some of you are thinking about trustees at your passing who will administer your trusts, meaning there's a first stage of administration. After our passing, if we have a revocable trust, Our trusts have to be administered and then ultimately distributed. So even though you may be a person who wants to keep the distribution simple, you want to leave the distribution outright to kids, grandkids, nieces and nephews, others. You're still going to have that administrative phase, and many of you may be focused on that. I want to know who the trustee is that's going to administer my trust, and then it would be distributed. But many of you are also thinking about the longer term effects of the trust, and that's what we've been really talking about this morning. Trusts can last forever if we want them to. So that's our first bullet point here. Why is trustee selection so important? Well, some of us are concerned about the administration and making sure our trustee is appropriate for that, to make sure that everything is properly administered and accounted for. But as trusts are administered, they are eventually distributed. And now we know those trusts can last forever. We don't have to have them last forever. Traditionally, many parents would say, my trust for my child only lasts till age 25 or 30 or 21 or 35. But now we know that trusts can be easily designed to last forever. Maryland, for example, has no rule against perpetuities. So that means that a trust literally could last until the money is gone. That's why trustee selection is so important. Trusts are more portable than ever. Many of you on this call, and I just spoke to a client this morning whose child lives in another state. Many of your children or beneficiaries live in another jurisdiction. So when you pass away and those trusts are established, that child or grandchild or niece and nephew could be living in various states. So trustee selection is very important in that regard. States are in competition for trusts. So some of you are aware of this, that in places like Delaware and Nevada, there's a lot of stiff competition for trust business, state income tax advantages, all kinds of bells and whistles that can be put on trusts. So trustee selection is very important because, as we're going to get to in just a few minutes, trusts should be flexible. And if our trustees aren't flexible, if they don't understand the modern contemporary world of trusts and estates, they don't have to be experts, but they just need to have an open-minded awareness of what is happening in the world of estate planning. Beneficiaries, as I mentioned, are very likely to change their domicile. So we need to take into consideration the fact that flexibility is important, not only for all the foregoing reasons, but because beneficiaries could end up anywhere, or they could live anywhere around the world, as we well know in the post-COVID world. Trustees have options. So why is the selection so important? They don't have to serve. They could agree today to serve, but they could refuse to serve tomorrow. I met with someone this morning who was talking about their plans to appoint an independent bank as a trustee. And I had mentioned to be very cautious because that particular bank, I had experience about that bank refusing to serve as trustee ultimately. So we have to be aware that even when we name trustees, we have to be careful about our successor trustees, because in today's world, there's no guarantee that they will serve. Now, not trying to scare anyone here on this webinar, but that's not usually going to happen, but it can happen. So we need to be aware of that. That's one of the problems we have in selection. Decanting, as I mentioned earlier or implied earlier, trusts can be changed today. Even irrevocable trusts can be changed. And one of the ways to change trusts is called decanting, literally taking an old trust and changing it into a new trust, which is actually kind of scary when you think about it. So we need to be aware of decanting. Our trustee needs to be aware of decanting, and they need to have, again, this basic knowledge and education, which we actually do here at Elville & Associates. We train or advise fiduciaries about these matters so that they have a working knowledge of what's available. An example of decanting would be if someone were a healthy beneficiary, a person that was in good health, they were neurotypical, they had no disabilities, they were a healthy individual, and at your passing, that person received a trust for their benefit. It was a regular general needs trust. But through decanting, that person's trust could be changed to a different trust if that person had changed life circumstances, such as a disability, or a brain injury. So decanting used in its positive mode can be a very powerful tool, and your trustee needs to understand those kinds of advanced concepts. Maryland does not have decanting yet, but Delaware and Virginia and many other states do have it. So you need to be aware, and your trustee needs to be aware of this concept called decanting. And I've already alluded to this, so I won't spend a lot of time on the last bullet point. Flexibility for changing circumstances is very important. So flexibility, I can't emphasize strongly enough that your trustee needs to not only be flexible themselves, but they need to understand the flexibility that can be built in to the structure of estate plans. And they need to understand that if they are in a bad situation with a very inflexible trust and circumstances have changed, they need to seek legal advice. However, hopefully in the design process, before that ever happens, before that circumstances ever arise, the flexibility has already been built in. All right, Jeff, I'm going to stop just very briefly to see if there's any questions as we continue to move to the next slide.
Thanks, Steve. Let's go ahead and look at some questions here. First one is, can one trust exist for one person and terminate at that person's specific age, and then the same trust would automatically be designated and revert to a second beneficiary?
Yes, I think that can be done. I'd have to look at your, thank you for that question, by the way. I think that trusts can basically be very, very broadly designed like that. There are some trusts that can and should only be for one beneficiary, but I would say given, depending on the circumstances, that could be the case. Usually what happens is a trust is for the benefit of a beneficiary, and perhaps it is terminated, and then another trust would be designated for the next person, and the person who the trust is terminated for, then that trust can flow into the other trust. So there are ways of getting from point A to point B. Thank you for that question.
Okay, the first part of this question is cut off, so I'm going to try to figure out what it's supposed to say. So I believe it's supposed to say, can a revocable trust become irrevocable after death and therefore a non-grantor trust? So the financial advisor duties you described to help trustee kick in after death in the case of a grantor trust before death.
Yes, thank you for that. If I understand your question right, and I'm just extrapolating a little bit on that question, you're exactly right. So a revocable trust is, of course, the grantor trust during life, identified by the Social Security number of the grantor. And then by definition, that revocable trust becomes irrevocable at death and becomes, well, if it leaves further trusts for individuals, it becomes a non-grantor trust for those trusts, and those trusts pay their own tax, which is a little bit of a discussion outside of this webinar. So you're absolutely right. And just to back up a little bit, when that revocable trust becomes irrevocable and has to be administered prior to distribution and accounted for, that is also a situation where we're dealing with that irrevocable nature of the revocable trust having become irrevocable, and that trustee of that administrative trust. That's one of the biggest confusing terms in estate planning worldwide, is what happens to my revocable trust? Well, it becomes irrevocable at death and becomes an administrative trust until the time of distribution. So that is where the 1041 comes in. Uncle Sam wants to know what the income is and who's going to pay the tax. Same situation when those non-grantor trusts are created at the time of distribution. Uncle Sam wants to know what are the incomes of those trusts and who is going to pay the tax. Jeff, any other questions?
Yeah, we have a couple more coming in. Can you please explain a marital deduction trust versus a non-marital? Thank you.
Well, thank you for that. So in a nutshell, if someone is married and they leave the proper estate plan it can pass by unlimited marital deduction to the surviving spouse. So the most simple way of thinking about it for purposes of this discussion is, let's say that you are married and you pass away. Well, if I leave assets to my surviving spouse, either outright or in a marital trust, then we are leaving assets towards and to the marital share. And then that's going to qualify for the unlimited marital deduction if certain rules are met, which basically means I can pass assets along to my spouse, and his or her assets, including mine that I left to him or her, will not be considered for estate tax purposes until the death of the second spouse. That's the way I would think about that. Everything is going to the marital share. Now, if I pass away, if you pass away as a spouse and you leave assets to the non-marital share, okay, there may be certain reasons why you did that, either for enhanced control or for tax reasons. But in today's world, with some exceptions, most married couples should leave, under the current law, should leave everything towards the marital share unless there are reasons not to. But again, everyone's circumstances are different, and that's just a real generality. Thank you for that question.
Okay, let's try one more. This question says, changing traditional IRAs to Roths. I know I pay tax. Is this advisable?
Well, thank you for that. So that is going to be an advisory team question. I strongly recommend that you approach that question with your financial advisor and your CPA and your lawyer all together. And I'll tell you why. There are maybe good reasons to do that. For example, perhaps you have beneficiaries who are going to get their share of your retirement plan assets, and those beneficiaries are healthy and well, and therefore they are not exempt under the Secure Act, and they're going to have to pay all the tax on that IRA, that traditional IRA, in 10 years or less. And maybe that's not what you had in mind. So there are ways of thinking about Roth conversions, slow Roth conversions that perhaps would make sense. And if you live long enough and are blessed to live long enough to kind of pay tax as you go and make up the difference on that, then in a sense you can beat Uncle Sam by leaving Roth IRAs to the kids and avoiding some of the big problems with the Secure Act. So there are maybe various reasons why you would approach Roth conversion, and I think it's a counseling issue. Of course, it's obviously a big issue of taxation, and the question is whether it's worth it. What is the cost benefit analysis? And again, everything is goal driven. Why do I want to do that? So that would be my answer to you.
Okay, thank you.
All right, Jeff, thank you. As we head toward now the latter part of the presentation, let's get into the trustee selection process. So I've given lots of background, and thank you for these wonderful questions. They're very helpful. The truth is, your trustee selection process could be very easy. You could have a very short list, a mental checklist of children, siblings, or other relatives that you know would be your trustees, okay? However, we just want to give due consideration to what I would call interested trustees versus independent trustees. Now, I'm not saying this is going to change your mind one way or the other, but it's something to know about, something to consider. The world of trust and estates looks at trustees in two different categories. A person is either an interested person. So for example, let's say that a sibling, a child, let's say, was the trustee for another child's trust. Well, some people think that's a good idea. Many times, of course, that's not a good idea. But my illustration is that those two siblings are related. So they are interested persons. So there are tax ramifications. There are issues having to do with asset protection. There are issues about just whether that makes sense to have an interested trustee as a trustee. Many of you are not going to worry about that. You're just going to focus on the right selection, and you're not going to worry too much about this interested versus independent scenario. But on the other hand, let's say we're leaving the properly designed trust for someone, and we have an independent trustee, a person who is not a family member. Doesn't have to be a bank or trust company. This could just be a person who's a non-family member, like a friend, a colleague, someone of high confidence that you appoint, that person is going to be an independent trustee. They are going to bring a different perspective than the family member. But beyond that, that person is going to have the ability to distribute assets according to various types of discretion that are going to increase the amount of asset protection. So Maryland, for example, allows a child or an interested person, an interested trustee, to be the trustee of that person's trust. But that may not always be the best thing. And if we are going to use a child or a niece or nephew or beneficiary as their own trustee, we're going to want to build in flexibility to be able to quickly pivot and change that situation if a crisis arises. Now, the trustee selection process is best done in a document review or counseling about wills and trusts, visualizing the scenarios, discussing the scenarios, illustrating those on a big whiteboard like we have here at Elville and Associates and all the conference rooms, going through a process to think. Conflicts could develop between interested trustees. So I alluded to this just a minute ago, siblings, for example, individual versus corporate independent trustees. So now let's talk about independent trustees. So again, I just mentioned that an individual could be an independent trustee. It doesn't have to be a bank. It does not have to be a trust company. Versus there are times when, and this gets to the next bullet point, some people consider corporate trustees to be an advantage. So let's say that your broker dealer, your corporate trustee or trust company is the trustee of your trust for your children or your spouse. Well, there are tremendous asset protection advantages to that. And that's beyond the scope of today's discussion. But a corporate trustee invests the money according to fiduciary standards. They are usually tasked with filing the trust tax return. All of those things are created in their responsibilities. However, we know that corporate trustees are expensive. They can be. So we have to be aware of fees. Individual trustees also are entitled to compensation. So it's not like, well, they're going to serve for free and these independent corporate trustees are going to charge a fortune. So we have to look at the overall costs. And if we are going to use independent trustees, or even if we're not going to use them, but especially if we're using independent trustees, we want to have a trust protector. A trust protector, for those of you who are not familiar with this, is an independent fiduciary, and that person has the right to remove and replace trustees. That person has the right to amend the trust. I mentioned this possibly earlier today, and possibly other powers. So to me, a trust protector provision is very important because Maryland now allows trust protectors since 2014. All right, Jeff. We just talked about the interested trustee versus independent trustee analysis, but let's just get a little bit more into that. There are different standards of distribution. An interested trustee might be distributing on a certain standard that is not as favorable for asset protection as an independent trustee. There are different points of view. If someone is a family member, we all know that our family members have certain preconceived ideas. They may or may not take their duty seriously as perhaps an independent person. I'm not saying they wouldn't. Different objectivity, different ways of looking at things, different levels of oversight. Let's say that you choose a family member who had all the best intentions in the world, but they just didn't do the kind of oversight that, let's say, an independent trustee would. Or let's take a scenario where either of those parties were not exercising the proper oversight. Well, our trust protector can be tasked with monitoring the situation at least annually and having conversations with those trustees to make sure that no matter who they are, that those trustees are exercising the proper fiduciary responsibility, including an accounting. And of course, there are different practical considerations. Everyone's family situations are different. Relatives live in different parts of the country versus the independent trustee. And there are various types of independent corporate trustees, for example. There are corporate trustees that I guess would be best described as they have retail packages. They're very expensive. And then there are corporate trustee services that are provided through certain financial advisors that aim to have a more cost-effective approach to having a corporate trustee. So all of this is about due diligence. All of this is about counseling. All right, Jeff, let's continue. And as I just mentioned, the role of the trust protector is extremely important. So Maryland recognized trust protectors, and let's just talk about the definition of a trust protector. Maryland recognized that in 2014. We at Elville and Associates were using trust protectors for many years prior to that. To my knowledge, trust protector idea has been around since around 2000, but we were using them in trusts long before 2014. The trust protector is a special fiduciary who has the power to amend. So think of the trust protector as a arm's length person who has the power to amend. Another definition is the trust protector has the power to direct the trustee in certain areas. And so we are very lucky here in Maryland to be able to say that we can appoint a trust advisor. That's what Maryland law calls it. But it's the same principle, a trust protector, as it's nationally known. And it's the power of amendment. It's the power to remove and replace. For those of you who are concerned, overly concerned, and I know some of you are, and rightly so, about the appointment of trustees, remember, if you appoint a trustee who is either a bad trustee, they become ill, they are unwilling to serve, God forbid, your trust protector, the properly chosen trust protector, will be able to fix that situation. And the way that you know that it's going to be fixed is through the education of family members. So let's say that you have appointed your trust protector, you've chosen your trustees. Well, have you made that known to your advisory team? Have you made that known to your family members? See, only through family counseling and education can family members really understand these concepts and, more importantly, know where they can go to get help. So trust protectors provide flexibility. They can be told to direct trustees in certain areas, mediate disputes, to review accountings. One of the most important things I can think of right now for the trust protector is to make sure that their role encompasses the ability to amend a trust for Secure Act purposes, because the Secure Act continues to evolve since 2020, with the most recent regulations being in February of 2022. So I cannot say enough about the role of the trust protector. It is not required, but we think it's essential, especially in certain types of planning, and it's something that you should consider, and it's a protection, just like it says, for not only you, the person who's choosing trustees, but it's also a protection for the beneficiaries and a resource for them. Okay, Jeff. Now, as we think about the practical approach, as we start to wind down the presentation, we know that trustees can serve in various roles. I mentioned trustees of lifetime trust, trustees of trust during life like revocable trust, trustees that manage the administration of trust, trustees that then are the trustees of further trusts for further beneficiaries. So let's just go through these. In wills, a trust could be created, and one of our nice questioners here, attendees had mentioned, what is the difference between a marital trust and a non-marital trust? This first bullet point is an example of that. A marital trust between spouses, or a bypass trust, which is the modern term for a non-marital trust. So a trustee under a will could be a trustee of a non-marital or marital trust after the death of one spouse. A trustee could be a trustee under a will for a young beneficiary who is, let's say, under age 30, for example. A trustee could be a long-term trustee of a testamentary irrevocable spendthrift trust. Now that's a mouthful. All that means is that's that long-term trust I was mentioning that is protected from the claims of creditors, except for exception creditors. And the trustee could be the trustee of that. Or the trustee could be the trustee of a testamentary trust of someone else that was established through another document or through the resignation of another trustee. All right, Jeff, let's go to the next slide. Now, the trustee's role in revocable trust is much of the same, but slightly different. I just mentioned as I started that prior slide, the trustee of a living trust is the person who is usually the grantor, but not always, and that's during life. And then the trustee of that living trust at death. Remember, that trust becomes irrevocable, as one of our listeners said, and then it has to be distributed. The trustee of a bypass trust or a marital trust under a revocable trust, the same concept of what can happen in a will. Trustees of young beneficiaries trusts under a revocable trust. Let's say someone was just providing for basic trusts for young beneficiaries. Trustee of their own trust. Let's say that there is an irrevocable spendthrift trust created under a will, or in this case, under a revocable trust. Remember, Maryland law says the beneficiary can be the trustee of that trust and have their cake and eat it too. They can have all those benefits, but we know that that's not necessarily a good thing. We want to be aware of that and always have the ability to shift if we need to with the help of a trust protector, or simply have an independent trustee from the beginning. All right, Jeff, let's go to the next slide as we wind down. As I mentioned, some of you will be more attracted to a corporate trustee. When I was a young lawyer, corporate trustees were not held in high regard. I have had good experience with corporate trustees, but I've also had negative experience with them. And the protection of a trust protector, I think, is essential. However, for those of you who feel good about a corporate trustee or who are thinking about it, are going to want to think about the experience of the corporate trustee in asset management and in trust administration. They are regulated by state and federal government. They are generally seen to be reliable and as a trustee of last resort, if nothing else. Although we're living in a changing world, anything can happen. They are supposed to be more objective, and I think that's pretty much true. They can be a resource or referral hub. They are deemed to be longer term, let's say. They hopefully will not die after a human lifespan. They will go beyond our lives. And they can provide peace of mind. So I think if we keep both eyes open in the trustee selection process and we build in lots of flexibility and we update and maintain our plans during our lives, and we don't let huge gaps of time go in between our updating, then we will be on top of our corporate trustee selection if that's the way we should go. And as we start to wind down in the end here, why should we be concerned about risk, successor trustee risk? So let's say that you have named your trustees and you are happy with them. Now, in the future, those trustees are serving. Well, we do have to be concerned in the selection process about age and experience. I'm of the opinion that just because someone is over age 70 doesn't mean they can't be a trustee. In this very conference room I'm sitting in right now, I had a person who was 105 years old about 4 or 5 months ago sitting in this room, and we've had many people live over 100. I think age and experience is good, but it also has to be considered a risk, of course. Health and health issues are going to happen over time. So those are risks. We need to be thinking about that. And again, the trust protector flexibility can be huge there. What is this issue of bond? Well, most trusts do not require bond. Most of you are not going to require bond because it's just too expensive to say to my trustee, you have to post a bond every year. And bonds can be extremely expensive and draw down the principal of the trust. So that's a risk that your trustee is serving without bond. So we want to make sure they're accountable. Other life changes for the trustee, divorce, creditors, bankruptcy, unforeseen things happening. And I know you're cognizant of that. Another risk is disconnection with the beneficiary or the needs of the beneficiary. We don't want to have a trustee relationship where the trustee is never in touch with the beneficiary. That's a bad thing for many reasons, and I won't go into more detail. Another risk is conversely, the demands of the beneficiary. Let's say that the beneficiary is extremely demanding, extremely difficult to get along with. Now we have to be concerned that the trustee may refuse to serve, they may resign midstream. We must take all this into consideration. And again, I sound like a broken record, but the trust protector is the factor, the X factor there that can make things work. Again, we want to have trustees that are willing and they have the fortitude and the perseverance to serve. It's a lot to ask them. They are entitled to compensation. There are two basic standards of compensation. One is statutory, and that compensation tends to not be what most trusts contain today as far as drafting provisions, because statutory compensation is considered to be very limited. So a trustee, generally speaking, would be entitled to reasonable compensation as kind of the modern approach, but that's something that needs to be considered, which is trustee compensation. All right, Jeff, our next slide. And as we really now are at the end, I just want to thank you for sitting through all of that for the last hour or so. And you've been a wonderful group to talk to with absolutely wonderful questions that Jeff and I appreciate. We want to suggest for those of you that are concerned about this issue that you come talk to us here at Elville and Associates. We do not charge generally for estate planning consultations or even to review your existing documents. We want you to know there's nothing to fear. We know these are very private, very personal issues. Here we are committed to client legal education and the education of family members. And we have a process, as I mentioned earlier. We not only have processes for estate planning and comprehensive education, but we also have a process where we can help you sort through your thought process and choices, really, of who should be your trustee. We can even help you interview trustees if you would need to or want that. Again, we want you to bring your current estate planning documents. We want to help you have an advisory team if you don't already have one, or if you're not happy with your advisory team, we can help you think through that issue. We love questions, so if you come talk to us, please bring a list of questions. We love that. Our goal is to give you time to think. We want to give you a place to think. In our modern facility here, we want to give you that space to think through these issues and be a resource to you. Remember, there's nothing to fear, and we do have processes to help you. All right, Jeff, I'm going to turn it back to you, and I thank you so much for moderating today and for everyone. Jeff, I think you're muted.
I think I am. No, I'm not. Sorry about that. A lot of buttons to push today. Okay, well, thank you very much, Steve. Great presentation as always. I know this is one of our more popular ones we offer on a quarterly basis. So we do have a few more questions that I'd like to get over your way before we wrap up on time. So I'll go ahead with the first one here. First one says, what does the insurance company mean when they say if the trust fails, the insurance benefits will go to the estate? This is when the revocable trust is named as the beneficiary of a life insurance policy.
Well, thank you for that question. As you probably are aware, I can't give you legal advice about that on this call because I don't know the facts and circumstances and we haven't formed a relationship. But generally, just from what I understand from that question, if you had left a life insurance policy to a revocable trust, I don't see a problem with that. And I think that that's a normal approach. That's a routine approach, I should say, many times. So a revocable trust should be able to receive your life insurance, and because obviously the life insurance policy is a non-probate asset. If it has a beneficiary, it flows through the trust as a non-probate asset. So that shouldn't really be a problem. What I would think is a problem if there was a life insurance trust and a life insurance trust wasn't properly funded, or if an insurance policy went to probate because it had no beneficiary, now that non-probate insurance asset has gone into probate and that becomes part of the probate process. So I hope I'm getting around the edges at least of your question, and I thank you for that. And I think that's my best answer right now.
Okay. Next question regarding corporate trustees. do corporate trustees charge a % of the assets?
Yes, so corporate trustees are going to have a fee schedule, and that has to be approved by the Secretary of State in Maryland. So the best way of looking at that is I'm interested in this corporate trustee, or I'm interested in these 2 or 3, and we're going to look at the fee schedules and get our minds around that and see what other services that their fee encompasses, such as tax preparation and so forth. And how do they manage assets, and what is their platform, and how do they provide accounting? So all of that is on a case-by-case basis, but the answer to your question is it's all going to be set out on a fee schedule, and to my knowledge, that's exactly right.
Okay. Next question, how are trustee bonds priced? Does it depend on the company the bond is purchased from? Is the price a percentage of assets?
Wonderful question. Bonds, I'm not an expert on bonds, but my experience has been that you're exactly right. It is priced on the size of the assets. It probably has something to do with the individual as well, and their credit worthiness, and as to whether they can even get a bond. But yes, I think generally along those lines, I'm not sure what the underwriting requirements are, but the last bond I saw for a $5 or $7 million trust that I was looking at was around $37,000 a year. So bonds can be extremely expensive.
Okay, next question. Can you recommend a book or other resource with examples of real trust language? I apologize, I missed that. I lost that question. Can you recommend a book or other resources with example of real trust language when conditions for staggered distributions or a perpetuity trust? I would like to learn more.
Thank you for that question. I have to admit, I'm so engrossed here at the firm every day. I haven't read any books that are out on the market about estate planning, because of course we're always reading professional material and so forth in our own world here. But probably in the various legal series that are out there, and I'm not trying to be funny, but the Dummies series, estate planning for dummies, or all these, some of the other types of publications that I know are out there, prolific books on estate planning. I'm sure you could find that. And if you wanted to talk about that, let's say, we would be glad to show you, let's say at a meeting, what that looks like and what those templates look like. But that's my best answer for that. And I think you could easily find that on Amazon and various publications.
Okay. Could you explain and discuss pour-over trust or pour-over provisions?
Thank you. So in a revocable living trust, we want to do those 2 major things. We want to design the trust and get it in place, and then we want to fund or align the assets in that trust and around that trust, like retirement plans. So that's the funding and alignment process, the 2-step process that goes along with revocable trust. For someone who fails to do that properly, which is unfortunate, either because there was no assistance, or they were left on their own, or they didn't really understand it, or life circumstances just took over, they never funded their trust, the backup will, or what we call the pour-over will, that will then sweeps up those assets, unfortunately, in probate, and then deposits those assets back into the trust. So that is called a pour-over will. So your revocable trust should have a companion will that's different. It's not the same kind of will that we would normally have as a regular structured will plan, but in a revocable trust, this pour-over will references the trust, and it also provides for guardians if there's minor children, and it addresses some other things, but it's a fairly small document compared to a regular will.
Okay. How would one identify potential corporate trustees?
Thank you for that wonderful question. Well, I think everything starts with your goals and values. It may start with your own particular relationships, the relationships that you have already. So if we were to further discuss that, I would want to look at who your current financial advisors are, whether they have a corporate trustee relationship, who your banking relationships are with, whether you've had any other persons in the family that have used certain corporate trustees, and we would kind of go from there. Now, if the answers to all of those things is that doesn't lead us in the right direction, then we would make certain recommendations based on your goals about cost and how much involvement you want with a corporate trustee and what kind of financial advisory services we want from all of those things would be encompassed.
Okay.
Thank you.
And looks like our last question for now as we wrap up here on time. How are trust protectors paid? A fee schedule or percentage?
Thank you for that. So trust protectors are still an evolving story. In some states, trust protectors are paid on a flat fee. Let's say if a trust protector was a trust protector on, let's say, I'm making this up, a South Dakota Asset Protection Trust. That person might get paid a certain amount per year just because that is the way things are done there. In Maryland, in routine planning, most of the things I see in documents and what we do in our documents is that a trust protector, unless we say otherwise, is entitled to reasonable compensation when they are serving, when they are having to do something, when they are having to consult, when they're having to change documents because they're amending documents or dealing with beneficiaries. So generally speaking, in Maryland, unless it's drafted otherwise, is the trust protector would be entitled to basically reasonable hourly compensation unless we agree to something differently.
Okay. And looks like those are all of our questions. If you have a burning question, get in right now for me, please. Otherwise, this is certainly a topic that is a counseling issue for a lot of people. So please reach out to us if we can be a resource to you in any way. Reach out to Steve or me. Certainly be our pleasure to be a resource to you and schedule a time for you to come in and talk with Steve for any questions that you may have. As far as our webinar series, briefly, next week is a very busy one. On Tuesday, we have answers to today's real estate questions with the Wendy Slaughter team. On Wednesday, Steve is going to be back talking about estate planning and elder law essentials. And then on Thursday, we have our very popular wellness series with Dr. Michelle Fritsch and Miss Ellen Platt of the Option Group, talking about know your why, purpose and meaning, fulfillment versus busyness. So should be a really interesting topic as always as we talk about our growing wellness series. So it looks like we see if we have any final questions. Okay, one more, Steve, then we'll finish up here. Where do you find a trust protector? Is it like a trustee you need to name?
Thank you. Yes, wonderful question. You have to think through this. This is another choice you have to think through. But the good news is we will help you think through that. A trust protector is someone who should be a non-family member. This is sometimes there are exceptions to this, but you really want to stay away from that. We want to have independent, arm's length people. And this is usually a friend of yours, your CPA, your lawyer, someone that you know at church, someone who's a person of high confidence, but is an independent person. And we want to also think about successor trust protector. So I know that's not an easy thing to start thinking about.
Okay. Well, that'll do it for today. I'll look for that follow-up email I always send out with some good information in relation to today's webinar. And we appreciate you being part of our webinar series and hope you have a wonderful day and weekend ahead. We'll see you again soon.